So do I have to have a QLR at my final hearing? So I see more and more of this. So this is why I'm doing a video on it today. Now, some of you may not even have heard what a QLR is, but if you are a litigant in person, and chances are, if you're a litigant in person and you've had allegations of abuse levied against you, this video is for you. So a QLR, qualified legal representative, is effectively a barrister that the court orders and pays for to attend your final hearing. But there is a vast range of them. But generally speaking, if you're a litigant in person, especially if there's allegations of domestic abuse, the law requires that you can't ask your ex the questions. You can't challenge your ex. You can challenge local authority. You can challenge CAFCAS, because the author of any of those reports will need to be there at a final hearing. But a QLR is the person that will ask the questions. Now, you're thinking, how does that actually work? And it'd be a great question, because they are simply there to ask the questions. They are the voice piece and nothing else. So my advice to you, if you are a litigant in person and you are coming up to a final hearing, first of all, get yourself a good Mackenzie friend. Just saying. Somebody that's got some clout, somebody that is known and can do cross-examination questions, because don't forget, your QLR on the day will simply just be asking the questions. Now, sometimes they will expand and do their own thing, but that is super, super rare. So if you think you're just getting a kind of a free barrister for the day, think again. Get yourself kind of in the know. Get yourself together, the script for good cross-examination questions, and that will be presented then to the barrister. In my experience, the QLRs are, like with most government-run things, tend to be a bit slow and a bit clunky, so don't be surprised if you have something that's a bit lastminute.com, a bit of an afterthought, because it is. But I think, as I say all the time, sing it with me, the magic is in the prep. So it really is in your paperwork. It's really in getting your team surrounding you. It's getting that if you have a Mackenzie friend, to be that person behind you that puts forward the cross-examination questions and works together with a QLR on the day to get you the results. Are you forced to have one? Yeah, if you're a litigant in person, yeah, that kind of is. But like I said, it's not necessarily a bad thing. In the old days, it's weird because, funds are really tight, and, I cover I cover courts all over the country. So I see such a vast array of how courts deal with this, Back in the olden days, which isn't that old actually, but back in the olden days, courts used to deal with this in a couple of ways. They'd either give rights of audience to your Mackenzie friend if you had one, or you would submit your questions ahead of the court hearing and the judge would ask the questions. That still happens, by the way, okay? Because QLRs they don't just grow on trees, okay? Like, legal aid's gone, government funding is at an all-time low, so don't expect that it's just a fait accompli that you will have a QLR. I've got lots of cases where that doesn't happen, actually. But if you are in a position where you have to have a QLR, again, magic's in the prep. Get your support team around you and be prepared. I hope that helps. Have a great day.